So what we're going to talk about today is basically entities and um, and what you should use when, or at least what a lot of people say you should use. Now, I do want to qualify this to say I am not a tax attorney and I am not an accountant. So what I'm talking to you about is the things that I think I understand over about 25 years of doing this. But it's important before you would actually take some significant steps that you make sure you check with somebody who does have the credentials in this area. This can be a fairly dry topic because it's a lot of legal stuff. So I hope I don't put you to sleep. And then the other thing I just want to say is that we are just kind of scratching the surface here. There is, because it's legal for the most part, there is a lot of nuance to some of this. And there's a lot of depth to it because a lot of this has come up out of various kinds of suits and different kinds of actions. The IRS posting things, states posting things. So what I do want you to be able to do at the end of this is to ask a lot of questions, because I am not sure how organized I was able to put this together. But here we go. So the first thing I want to talk about here just briefly is to make understand that there is a difference between entities and asset protection. A lot of times we think of entities like LLCs and C Corps as asset protection. And yet it is only one piece of what you need to think about when you're thinking about protecting your assets. And so when I think about asset protection as a big as the whole, the things that we talk about adding in this are entities for sure, but liability insurance is probably a bigger part of asset protection actually than the entities are, because and we're going to talk more about that, but liability insurance is when you are dealing with your properties or whatever, that you have insurance to get liabilities in case somebody falls or hurts or something happens. Most of the time when people sue you, they're not interested in you per se, although attorneys really want you to think they are. What they're interested in is getting the insurance money. And when you start getting in trouble is when you don't have any liability insurance. Other part of asset protection is life insurance, because if anything happens to you, you don't want your family and friends to be able to not have anything because you didn't have any insurances. Another big part of asset protection is doing business in the correct manner. So not kind of making sure that we are being fair and above board and not trying to do things kind of in a sneaky way. That gets you in trouble a lot. Following the law. It's when we don't follow the law or landlord tenant laws that we get ourselves in trouble. And then trusts are another part of asset protection. Now, I want to tell you that anybody who's been in this business for a while and does any amount of business is going to most likely find themselves sued at some point or the other. I wish it wasn't true, but it is. And I've been sued more than once, or my companies have been sued more than once. And so it's a fact of business of being in this that you need to take asset protection seriously. Okay. I want to talk just a little bit about what entities do. Entities are supposed to protect you from others. But most of the time, when an entity is pierced, or in other words, a lawyer can get through that and get to your personal assets, it's because of your own actions. So most of the time, when there is a problem with our entity getting pierced, meaning the court says that they can get to you as a person, it's because we're not following the rules that have been laid down in law by the feds or the state in terms of what you have to do to make sure that you are in compliance with the law. So if you think about it in its broadest terms here, that and that when we're talking about and when we're talking about businesses, particularly LLCs, when we're new to this, there is a tendency to, even though we know that that an LLC or a corporation is a different than us. It's considered a separate person. We don't really treat it like that. In our mind, it's attached to us. It is us, and that has to stop. It has to be thought of as another totally different person. And what we do in the role of our business entity, we can't cross that into another business entity or into ourselves. They have to be kept separate. And it is most often when we don't keep them separate that it opens up for a lot of problems. And we're going to talk about that just a little bit more. So the things that can normally have your entity pass through, so it kind of, you lose the protections, is negligence. And flat out, if you are not doing things correctly, you're being negligent, it is you that's being negligent, not your company. And so that goes straight through to you a lot of times. Some of the problems we're going to talk about with other types of organizations like an LLP is that if somebody else does the action, is negligent, or an LLC, it falls to you as well. So it is not just separate. So you can't separate yourself out from some of these entities, and you're going to get carried down with it. Landlord-tenant issues. So this is what I think, rarely do plaintiff attorneys go after your personal assets. They generally just want the insurance, but they're going to threaten it all the time. And that's what tends to scare a lot of us. I want to just kind of reiterate that last bullet there. Entities are for business assets and trusts are for personal assets. So you hear a lot of times, and we're going to be doing a class or one of these Teaching Tuesdays on trusts here before very much longer, so that we can kind of separate those out. But a trust is basically used for your personal assets, like for instance, your ownership interest in a company, rather than the company itself, is a personal asset. So a business asset like a house or an apartment building is actually like an LLC or another kind of asset, whereas a trust is your interest in that. And I don't know if that's quite clear, but trusts are used for, in general, privacy protection, but most of them do not provide any actual asset protection. So a lot of trusts are set up with the beneficiary of the trust is actually an asset like an LLC. So trusts provide privacy. They do not provide asset protection. And that's really an important takeaway in this. Okay. This is going to be contrary to what a lot of people have heard and been talking about, but not too long ago, I actually went to a presentation in Puerto Rico that was a couple of days on nothing but asset protection. And it was given by a tax attorney who's probably one of the best in the country. And what he said was that LLCs are the best thing to use 99% of the time. That the idea of a corporation, C or S corporation, limited partnerships, LLPs, are not very flexible. And they're not as good as an LLC. So limited liability company, we can use it in a lot of ways. We can use it as a partnership. We can use it as a C Corp, an S Corp, or we can use it as a disregarded entity, right? It's how we choose to have it taxed. But we can also choose to not say we want to be taxed under certain rules. LLCs fall down. They fall into your individual tax. And so they're not like a C corporation. You're going to file a personal tax and you're going to file a corporate tax. And so that's where the idea, a lot of times you get taxed twice. In an LLC, you can you can act like it is a C Corp or an S Corp or a partnership, but you also don't have to elect any. And there's actually some benefits from not electing to be taxed in one specific way. So corporations are generally obsolete. And when they are used for the really big businesses that have a need to have shareholders and other things. In corporations, there are no charging orders, and we're going to talk about a charging order here in just a couple of minutes. And they're older and less flexible. So I know a lot of people, in fact, one of my partners works out of basically a corporation, which causes her some heartaches sometimes or some headaches. Limited partnerships. That's another way to be that's another entity structure. The downside to limited partners is that you have to have a general partner in a limited partner. So you have to name a general partner. And the general partner is the one who has all of the risks associated with most of the time. Again, the rules are older and less flexible. I will say that in a lot of the English-speaking countries like Canada, Britain, Scotland, and I do believe Australia, they use LPs a lot. LPs are also used, and LLPs are used in professions. So you'll see accounting professions, you'll see physicians and dentists and those practices set up as an LLP or an LP. And there's some benefits with that. But if you're basically in real estate, not so much. All right. Okay. So some of the benefits of an LLC is that there aren't as many requirements for maintenance. So it's harder, you don't have to work quite as hard to keep the entity separate. It's more forgiving of a lot of issues, and there is charging order protections. So what is a charging order? It's a way, if somebody were to sue you or to sue your company, but they don't get to you individually, but they get a judgment against your company, against your LLC. It's a way, a charging order is a way to protect the business from personal debts or liabilities that you may have, right? It can put a lien on your shares, on your part of the LLC, but it does not allow the creditor to take over your rights to do business. And they have no right to say what happens with that business. So businesses can continue to operate without being affected by financial troubles. They can continue to operate without the person who has the charging order being able to tell them what to do. Whereas S Corps and C Corps, if somebody gets a judgment, there's actually ways to force the sale of some of your assets in that, some of your position in that, and they can step in and tell the corporations what to do to a certain extent, because there is no charging order protection. Most of the time we don't use this, but it is a strong benefit when we do. So if you think about it, 2 or 3 of you own an apartment building and something happens and somebody gets sued, and the judge or the courts say that that person who owns part of your LLC is liable, and there's a judgment against them, right? In an LLC, that person that has that member of your team who has the judgment, the person who is owed the money can't come in and tell the others parts of the owners of the LLC what to do, or force them to sell the property, etc. And they can do that in corporations, and particularly closely held corporations. So it's something we just want to try and be aware of. Okay, let's try and talk. So this is sort of a kind of a buyer beware a little bit. Anybody who's been around real estate and real estate education for a while knows that there's a lot of different kinds of classes out there, and that people will teach you different things, and that they are willing to do certain things for your business. And one of the areas where services are offered are various asset protection services. And in my humble opinion, and I obviously I can't say too much, is that some of them are not quite, they say things that are true sometimes, but not most of the time. And so you see a lot of those out of Nevada and Utah. At least that's where I seem to see a lot of them coming up with. So for instance, a typical thing that you're going to see them tell you is that if there's a charging order and that charging order says that you are supposed to pay out what is owed to the creditor anytime there's a distribution. So what these people say is that because there is a charging order, because a creditor, that the creditor actually has to pay the taxes on the debtor's pass-through income. But this is generally not true. So you still, most of the time, are going to owe the taxes. And so people sort of talk about this in terms of the poison frog, right? So sure, you can sue me and you get a charging order, but now you are responsible for all my taxes and I don't have to give you a distribution to pay for those taxes. Most of the time, that's not true. So I have one, there's lots and lots and lots of different, whoops, I'm sorry. There's lots of different cases out there that talk about this. That one of the typical rulings is a limited partner has assigned interest to someone else and the debtor becomes the assignee. So it's the same thing in Evans versus Commander. It's just a lien that they're basically, so think about a charging order as a lien, and that lien says you have to pay over any distribution that would have been paid to the judgment debtor. Where people get in trouble is trying to say that there just wasn't any money to distribute. And they do that by making loans to other companies, by consulting fees. And a lot of times that actually ends up in criminal contempt. There's also, based on some of this, that you will see fraudulent transfers of ownership. So it transfers from me or from Charlene to her husband and puts it in their name, so it gets it out of your name. Those are all fraudulent transfers. There's a lot of fraudulent transfers. So the issues here become, if for something happens, you need to just kind of fess up to it and try and deal with it in a get it paid off, deal with it in a typical way. So the other thing you see that I've seen a lot of, I think, is that when these things go to court, when they actually get to court, and remember, most of them never do, it's settled out of court, it really isn't, it's really the judge who's going to make the determination. And they use law as kind of a basis, but a lot of them are really making decisions based on what's actually happening, what they actually see. And so it's how they judge it. And so the issue of being able to really have a cogent and factual story to tell, and something that isn't going to get you trouble looking like there's a fraudulent transfer or something, in my opinion, is really the way to go with a lot of this stuff. Otherwise, you end up, if it ends up in court, you can find yourself in a lot of trouble. Okay. So we're going to talk about single member LLCs for a minute. So for a lot of times, and I did this too when I was starting, when you start an LLC, you're the only person who owns that LLC. It's 100% owned. Having 100% owned single member LLC makes it a lot easier for a court or an attorney to make a case that you really are not a separate person from your LLC. So it's easier to prove or to say that, you're really, it's one and the same. A single member LLC is really the same as you as the person. So the current thinking a lot of times is it's better to have more than one member in an LLC, more than one person as an owner in an LLC. Now, it can be you and another LLC. It can be you and another person. It can be you owning 95% and somebody else owning 5%. But the idea is that you really don't want to have one person and everything flowing through directly to your taxes. So think about if you have more than one member in a company, what you typically do is an accountant will look at that and they will do the taxes for that company and they will issue a K1. K1s come in when there is more than one owner. I think you're better off really don't have too many, if any, single member LLCs if you can avoid it. There's been several states and several cases where the case has been made successfully is a single member LLC is the same thing as you as the person. So just be aware of that. There are a few states that really are fairly strong and are not going to cause you to have a lot of problems with a single member LLC. They allow them and they are strong proponents. And some of those are Alaska, South Dakota, Nevada, Delaware, and Wyoming. I think most people think now that Wyoming is the best state for forming entities these days because of asset protection, because of privacy, because of how the state just kind of views ownership. And so take that's what it's worth. But if you're going to form an LLC, I would talk to somebody who knows a whole lot about this. But if you do form an entity out of your state of where you live, that you're still going to have to report in your state. So you're still going to be doing taxes. You're going to be doing taxes in wherever that LLC is formed, and then it rolls into your taxes. So you're still going to be having to file in two states, which is a downside to this. All right. This is kind of the last slide I want to talk about here. This is just some basics 101 of how do you avoid piercing the veil of an LLC. What can you do and should you be doing? The single biggest thing I think is that you must, and I'm underscoring must, have a separate bank account. One for you personally and one for your LLC. And you cannot commingle those at all. That in and itself is enough to all by itself to pierce the veil. So you have to have separate bank accounts, and it is very easy for attorneys and accountants, if you're being sued, to track that. You can't commingle accounts between two companies. So if we, James and I have two education companies, a single family and a multifamily, we can't commingle monies in those two entities. We can't be loaning money back and forth from one to the other, one company paying the bills for the other, right? That makes a pretty strong case that now you are not separate entities. You're not treating them like they're a separate person. You're treating it like it's one and the same, right? Each company has to pay its own bills. And if for some reason you do have to commingle, you have to have a reimbursement plan and document. So you have to have a note, you have to have a payment schedule that gets paid back and that it is actually paid back, right? You have to do an income and expense statement. You have to do a balance sheet. So again, a separate finance, it's a separate entity from you. And you are going to be doing their own income statements and balance sheets. You have to do corporate minutes and resolutions. So before you can take a big action, you should have a meeting of your LLC members, make a recommendation, make a resolution, get the minutes. You have to have some way where you've decided how you're going to make decisions. What are your procedures for making decisions? Most of the time, those things are in your operating agreement. I know a number of people who have LLCs that don't have operating agreements. And you need to get one if you don't. And part of what you need to do in those is to follow the decision-making, to say how often you're going to have meetings, that you're going to have minutes. The other thing is whenever you do, and this one is a biggie, whenever you sign a document, you have to sign it as manager, or when you have a signature, underneath your signature, it has to have the name of your company, LLC. If you're doing emails that are company business, it has to be signed by you with your company name below it. So it becomes clear that it's not you as an individual, it is you representing the company. Right? You always, always, always put the name of the company and your title in it. Now, way back when, that was a mistake I made. I thought I was doing a solid for somebody else and was helping them out. And I signed a couple of documents and I did not sign it with the company name. And I got, when we got sued, that was my bad. And I was in trouble because it looked like it was me personally who was making this offer, who was doing this. And so it wasn't the name of the company, so they could come after me as a person. It seems stupid and trivial, but believe me, it's not. Okay. And that you have, if you're going to loan money, you have an actual loan document that's a reasonable interest rate, etc. Right. So these are some of the things I wanted to cover. They're just basically covering the tip of the iceberg. But it's important, I think, that we kind of think about these things. All right. So most of you have done this before, been here before. You know that we have a multifamily class that's about 60 hours in length. It's 36 modules. And if you want to know more about what is included in that and get some free education, then we have done a webinar that you can get that there at the Passive Wealth webinar. Our company is passivecashflowforlife.com, or not our company. That's our URL. If you have questions, send emails to support. What you see next is our YouTube channel. And these and other kinds of classes we do go up on the YouTube channel, and they should be up by the end of the week. You can see any of the other Teaching Tuesdays we've done. We have a playlist there. And so I think that's kind of what I wanted to talk about in this class. And I know we've kind of been a little bit all over the waterfront, and this ran a little bit late. So I'm sorry for that. I'm going to open it up for questions. James, have we got anything there?
No, not yet, but it's interesting you talk about, and this is something you taught me a while ago, but I signed a contract today for some services. And I signed it as, James Rey, manager, reach. So I'm covered. So
Yep.
it's a really good idea. It only takes a couple extra seconds. But it's a really, really good idea to do that. And I think Aisha has a question. Go ahead, Aisha, you can just unmute.
Hi, thanks for giving the presentation. Mine is about insurance as it relates to protection. Well, it's a two-part question. So the
Okay.
first one is do you recommend like having umbrella policies, like an umbrella liability policy attached to your normal like homeowners policies for your for rental properties? And then the second one is, how do you feel about the life insurance plans that they say you can use it as your own bank to help you pay off loans and things like that? What are your thoughts on those?
Well, those are both two really good questions. So the first one is an umbrella insurance, which means that um, you cover. So let me just kind of back from. Remember, we're talking about you and an entity, and you're two separate. You're two separate people. So an umbrella policy cannot cover you personally and your business because they're two separate entities. What they can do is that if you have more than one multifamily property or more than one house that are owned, that are in different companies, you can have a insurance policy on property A, property B, property C that might be, say, $500,000 each, and then an umbrella policy that sits on top of that that covers all three of those properties in case something happens and you get sued and it exceeds the limitations on the policy. It's an extra level of protection. And I don't think that's a bad idea at all. If you're going to use it like that for your properties, then one of the ways you do that is to make sure the ownership of each of those properties has to be the same. So it becomes a bit of an issue if you have one partner in one and a different, kind of private lender in another one, et cetera. It becomes harder to figure out how to do umbrella policies like that. Now, I have an umbrella policy personally. So I have one, I have insurance on my house, I have insurance on my car, I have insurance on some other personal stuff, and I have an umbrella policy that covers them all, that sits on top of it. I think what you get with an umbrella policy, because they tend to go from, you have your main insurance that's sitting at, say, $1 million, and your umbrella is at 5 or 10, then what you end up with is the meanest, biggest, nastiest in attorneys that are out there that are going to be working for you, because the umbrella policy is going to get pulled in anyway. And so they're relatively cheap. They're $200 or $300 a year most of the time. And so I think they're good things to have. In terms of life insurance, everybody knows there's two big types of life insurance. There is whole life and term life. And the way life insurance policies tend to work is that you're going to pay out a certain amount every month until you get to a certain amount, and then and you can borrow against it. It is a way to do that, to borrow against it, but now what you're doing is you're running the risk of not having it if you need it. Most people are going to go for a term life insurance because it's a lot cheaper. But what it means is that at a certain term, the life insurance goes away. And it tends to go, a lot of them tend to go down a certain amount every year until you get to 75, say, and now you don't have any life insurance because it's totally gone away because it's had a term. And it's the way that the insurance companies actually avoid having to pay out a lot of time. Whereas whole life, it covers you for your whole life. It never goes away. The amount never goes away. That's more expensive, and you have to decide what you want to do. There are people who certainly borrow against their life insurance policy to pay for things. Unfortunately, a lot of people never pay it back. And so now your life insurance isn't worth as much and you continue to pay. Did that answer your questions?
It did. Thank you, Nichole. That was helpful. Thank you.
All right. Other questions?
Hey Nicole, hi. This is Hits. I have a quick question about the commingling of the funds. If I have an LLC set up in Wyoming, and let's say the name of the LLC is like ABC, but I'm buying properties, let's say in North Carolina, and I did a foreign filing, and let's say I did not got the exact name ABC, but in North Carolina my LLC's name is XYZ. So do I need to have separate bank accounts with the LLC name ABC and XYZ, or is it eventually a same entity but just with the different name?
Well, my first question is, are they, so when you set it up in North Carolina, say, and you bought a property, did you buy it in the name of your Wyoming LLC or did you buy it in the name of another company?
I bought it in the name of the North Carolina LLC name.
Okay, so they are two separate entities. They are two separate. So and I'm not saying that this is right, but what it sounds to me like is that your Wyoming company is kind of a holding company.
Yes, it's like a parent LLC.
And what it does is it owns the North Carolina LLC. Is that correct?
Yes.
Okay. Those are two separate entities. They're two separate people. And you cannot commingle those accounts. Otherwise, you find yourself in trouble. So you gonna need to have bank accounts for both. It doesn't have to be, they don't have to have a lot in them, but you do need separate bank accounts. You need separate minutes. You need separate, when you sign, if you're signing for your property company, you're going to sign in the name of the property. You can also sign in your signature for both LLCs. You can have the name of both LLCs on your signature line. But commingling of assets, commingling of bank accounts, of monies is an issue. And a lot of people do it without really kind of understanding the ramifications of it. So if you're doing that, at this point, no harm, no foul, but go fix it. open
Okay.
another bank account. If the Wyoming LLC is just kind of holding on, you don't need to have a lot of money in that.
Mhm,
But I would open a bank account in the other state.
mhm.
And make sure that you don't commingle, that you do minutes for both, etc.
Okay. Okay. It's just because I never actually opened LLC in North Carolina. So I only have operating agreements and everything for the Wyoming LLC, which is the parent LLC. I only did the foreign filing, which was just like
Okay,
a one-page document, which just enables me to operate and
okay.
do
So
and do.
it's the same LLC then.
Okay, okay.
So your parent LLC, when you took ownership of your property,
Hmm.
it was in the name of your Wyoming LLC.
Hmm.
Is that correct? So
Yes.
who's on the deed is your Wyoming LLC.
Uh, and and actually, that is also one question I have. Since I am operating in North Carolina, shouldn't I use the North Carolina LLC name in all the purchase contracts?
You, so this is my bias. If
Mm-hmm.
I have a, for my holding company, M&A Investments, it's a Maryland LLC.
Mm-hmm.
But when I am buying in the other states that I'm holding property, I am opening an LLC in that state.
Okay.
And so, for instance, I have a, let's say I have a Horizon Homes LLC in West Virginia,
Mm-hmm.
and Horizon Homes LLC is owned by M&A Investments. It's partially owned by M&A Investments LLC.
Okay.
So I am filing primarily in West Virginia on that LLC, and there's a K1 that rolls up to my Maryland. My bias is if you are having properties in North Carolina, you're probably better off buying it in a North Carolina LLC, because then North Carolina laws are going to is what you're going to be assessed under, and
Mm-hmm.
then that property is owned by your or at least partially owned by your Wyoming LLC. So the deed or the operating agreement would show that the ownership of XYZ LLC is part ABC Wyoming LLC, part somebody else. And so your operating agreement is where you typically show the ownership.
Mm-hmm.
Um, I would try and get that straight to make sure how this is set up, because what you don't want to do is commingle funds, commingle minutes, commingle those kinds of things. They are separate persons, basically.
Okay. Understood.
And then
Other
Charlene has a
questions?
question. Yeah, Charlene has a question.
Okay.
Okay, when you said separate accounts, you meant separate accounts, not separate banks, or is it best to do separate banks?
It can be either. They're separate accounts. It can be the same bank, but you would have an account for your holding company, or if you have three properties that are all in their own LLCs, you'd have three bank accounts, one for each. Did that answer that?
It did, but my underlying question is with these. Okay, so let's assume that it's not if you get sued, it's when you get sued.
Okay.
Okay, so it could happen one day. So let's say somebody's kid falls off the staircase, off of the stair rail around, the different floors or something, or something else happens. And so if you have these things in separate does it make a difference? Would it make a difference to have it in separate banks? Or as far as someone piercing and all that?
Oh, I see where you're going.
Yeah,
I really don't know, because if it gets to that, the first thing attorneys are going to do is do a discovery.
yeah,
And they are going to ask you for all the assets you own. Now you can push back, but they can go look to see if they can figure out all the assets you have. And
okay,
that's one of the reasons I have a lot of different LLCs by different names, is that you want to separate things.
yeah,
One of the reasons to have separate banks isn't so much because you have different, you might get sued, I don't think, as it is if you really look at your loan documents with different banks, is that in those small prints, it's going to say that if one property that you have gets in trouble and you have other loans with them, that they can go get the money out of that other bank account to cover this. So you are cross collateralizing those properties if they're in the same bank, whether you know it or not.
mm,
And that becomes more of an issue to me of why you might want different banks.
all righty then. Great.
Okay, other questions?
I do not.
I think we're about done. I have time maybe for one more. I'm gonna question, and then I need to turn it over to my partners.
And Nichole, I
So
have a quick last question. Do you recommend to keep only certain number of properties in one LLC just based on how much equity you have, so that you keep it like you don't want too much equity in one LLC, or just based on the number of properties?
well, I am biased towards, I mean, it's more record keeping and it's more tax work, etc. But I'm biased about having a limit on the dollar amount, for lack of a better things, that is in any LLC. Now, if I have a big multifamily property, it's going to be its own LLC, and I'm not going to put anything else in it. If it's single family houses, I will hold, I mean, that's your own decision, but I'll hold 15 to 20 houses in one LLC. But if they are $500,000 houses, I don't want 10 houses in one LLC, because that's $5 million. Although you might, so it really is about anything in one LLC is any asset that's in that LLC. If somebody sues you, they can come after all assets in that LLC. They can't go after your assets outside that LLC unless you've been negligent or the court says they can. So the real question is, how much money do you want to have at risk? And that can be equity, it can be the value of the property itself. And that's sort of a personal opinion at this point, because I have enough properties that, having 5 to 10 millions in an LLC seems reasonable to me. But when I got started, I got nervous if I had more than 5 houses in one LLC, because I just didn't have that many assets. Did that answer your question?
Yes, Nichole. Thank you very
Okay,
much.
you great. All right, I am going to hand this over to my partners, Jane and Sharon, and let them take off the